1621, the Prohibiting Punishment of Acquitted Conduct Act of 2021 as amended.
The clerk will report the title of the bill.
H.R. 1621, a bill to amend Section 3661 of Title 18, United States Code, to prohibit the consideration of acquitted conduct at sentencing.
Pursuant to the rule, the gentlewoman from Texas, Ms. Jackson Lee, and the gentleman from Oregon, Mr. Bentz, will each control 20 minutes. The chair recognizes the gentlewoman from Texas.
Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous materials on H.R. 1621.
Without objection.
I yield myself such time as I may consume.
The gentlewoman is recognized.
Mr. Speaker, I'm very proud to support H.R. 1621, the Prohibiting Punishment of Acquitted Conduct Act, which offers a solution to a long-identified problem within our criminal justice system. This bill provides necessary reform to current federal sentencing practice that allows judges to sentence defendants based on conduct which a jury has found them not guilty. The Sixth Amendment to the Constitution provides that anyone accused of a crime shall enjoy the right to a speedy and public jury trial, while the Fifth Amendment provides that no person shall be deprived of life, liberty, or property without due process of law. These provisions mean that the government is bound to move each and every element of an offense for which a defendant is charged beyond a reasonable doubt during jury trial, or that defendant must admit each element of an offense to support a plea of guilty. Absent that, those offenses are not found guilty, if you will, to the individual. Notwithstanding this constitutional obligation, federal judges routinely nullify not guilty verdicts rendered by juries and sentence defendants to significantly higher penalties based on acquitted conduct. In its current form, 18 U.S.C. 3661 prohibits any limitation of the conduct a judge may consider when sentencing a defendant, even when a jury has determined that there was insufficient evidence to prove the defendant committed the charged offense. Seems clearly a constitutional violation. Additionally, under the concept of relevant conduct, the U.S. sentencing guidelines allows judges to consider a range of conduct, including dismissed charges, uncharged conduct, and acquitted conduct when imposing sentences. Again, might I say, seemingly a very unfair direction given without limitations and certainly without adherence to the constitutional amendments. The fact-finding made by judges at sentencing is based on a lower evidentiary standard than at trial, that is by a preponderance of evidence, which many scholars define as a 50% chance that a claim is true. The reform proposed in this bill ensures that judges punish defendants on facts proven beyond a reasonable doubt. Criminal standard, the higher evidentiary standard of proof required during a jury trial, which some scholars attach a value of 90 to 95% surety. Justice Ginsburg, a moderate liberal who became more liberal in later years, joined Justice Thomas, Justice Scalia, a staunch conservative, in his dissent in Jones versus United States, lamenting the failure of the court to determine if the Sixth Amendment is violated when judges impose sentences based solely on judge-found facts. While the sentencing guideline suggested prison sentences from 27 to 71 months for the 3 defendants in the case, the trial judge imposed, if you can believe it, an overwhelming sentence of 180, 194, and 225 months based on the conduct the prosecution failed to prove. Judge Scalia's often quoted dissent was issued more than 7 years ago, yet nothing has been done about this unjust, undemocratic practice and really unconstitutional, which diminishes the sanctity of the jury trial, the standard of unreasonable doubt, which any layman can tell you when you ask them what is the standard for proving guilt or innocence in a criminal trial. Everybody knows the words with unreasonable doubt. Can you imagine? That is not the case. The public check on the government's power and the overall integrity of the criminal justice system must be maintained. H.R. 1621 would restore fairness to jury trials by amending Section 3661 to ban consideration of acquitted conduct at sentencing unless the conduct is considered for mitigation purposes. Though I wish we were doing more to advance the standard of criminal justice reform, I am happy to support this bipartisan bill that addresses an acute need while restoring the basic propositions of due process and the right to trial by jury. I want to express enthusiastic support and appreciation to Representative Steve Cohen, Chair of the Subcommittee on Constitution, for his commitment to justice and for taking the lead on this significant bipartisan bill, along with Representative Kelly Armstrong. A broad coalition of advocates support this measure, including R Street Institute, the ACLU, the Innocence Project, Brennan Center for Justice, the American Bar Association, Families Against Mandatory Minimums, the Leadership Conference on Civil and Human Rights, and the Federal Public and Community Defenders. It is for that reason I hope that the Senate will take up this bill and pass the House version as soon as possible. I ask my colleagues to support this bill and to continue working on additional measures to make our justice system more equitable and more transparent. We look forward to coming to the floor with those initiatives. I reserve the balance of my time.
Gentlewoman from Texas.